my colleagues at the Eugene Dupuch Law School, Mr. President of the Bahamas Bar Association, students, distinguished ladies and gentlemen, everyone, good evening again. With my colleagues and friends at the Eugene Dupuch Law School, I take great pleasure in welcoming you to the 2023 Eugene Dupuch Distinguished Lecture. We are especially happy that after 2 years of this event being held virtually, we're able to gather in person again, prudently, but despite the challenges we still face with COVID-19. The law school's primary objective, as you know, is to provide training for attorneys-to-be. However, we regard it as our responsibility to engage in thought leadership and to stimulate in various fora meaningful conversations around matters of national, regional, and international interest. When I asked Sir Ian whether he would consent to delivering this lecture tonight, I pitched it against the Bahamas' 50th anniversary independence celebrations. He said, boy, you sure making it hard to say no. We're very glad that he consented. The topic of the lecture that will be presented tonight is status, rights, and obligations, legal issues in citizenship, immigration, and asylum laws in the Commonwealth of the Bahamas. The importance of this topic is underscored everywhere in the media, almost every day, and throughout our society. We thank you, Sir Ian, for agreeing to present this lecture, and I now ask you to welcome Mr. Darren Ellis as he comes to introduce Sir Ian.
Good evening, ladies and gentlemen. It is indeed a pleasure to introduce our featured speaker this evening. A few years ago, Madam Principal asked me to introduce another speaker. I admitted at the time that I didn't know of him, so I had to do some research to prepare and properly introduce him. This time, however, I have some knowledge of our speaker, and so very little research is required. I met our speaker in 2007. I was completing my first year of law school, and in order to graduate from law school, at the time, one had to intern at a law firm. I had yet to decide which firm I was going to work at, but I had this friend who had an idea. He said to me, Ellis, let's do our in-service training at the law firm of Davis & Company, as there are many fine, pretty girls working there. Being the shallow person I was at the time, I felt that was a good idea. Davis & Co., pretty girls, I mean, what is there not to like? I must clarify, however, that I've matured and I do not make those kind of decisions anymore. But this decision in particular was one of the best decisions of my life because it allowed me to work under the tutelage of our speaker. This assisted me tremendously in my professional and personal development. I have not met another person with such an excellent combination of intelligence, humility, and respectability as our speaker this evening. In 2007, despite his stature as a partner at the firm, he treated me as if we were equals. He led and guided me in the law and made me feel as if my input counted. He seemed to genuinely care about my well-being. I always remember one time I was leaving the Court of Appeal, walking back to the office, and I happened upon our speaker on Bay Street. He asked me how it went. I wanted to lie. But I told him the Justice of Appeal, including the President, beat me up. But I learned a lot. And I told him I was heading back to the office. And he told me, no man, whenever you finish with court, do not go back to work. get a beer, get a cocktail, and relax. Well, you didn't have to tell me that twice. Since then, whenever I had caught, no matter how short the duration, I would go for it and be done for that day. But that was him. So Ian's practice was primarily in the area of civil and commercial litigation, so he well knew the mental and physical toll litigation could have on you, and that one should find time to recharge. And it was not only me he did this with. In observing him, he treated everyone this way, lawyer or non-lawyer, rich or poor. In this regard, in working with our speaker, he not only taught me the law, but he demonstrated how we all should treat with one another, always with a high level of grace, respect, care, and integrity. Ladies and gentlemen, I've doubly served as a Justice of the Supreme Court of the Bahamas since 2013, and as a Justice of the Court of Appeal of the Turks and Caicos Islands from 2020. The Honorable Sir Ian Winder was appointed Chief Justice of the Commonwealth of the Bahamas on the 3rd of August, 2022. His Majesty King Charles III awarded Sir Ian a Knight Bachelor in October 2022. In his capacity as Chief Justice, Sir Ian chairs the Judicial and Legal Services Commission. He is an ex officio member of the Court of Appeal and is the president of the Bahamas Judicial Education Institute. I would not forgive myself if I had failed to acknowledge the lovely wife of Sir Ian, as she gives credence to the old adage that behind every great man, there is a great woman. Sir Ian is married to Lady Marie Jacqueline Winder, and together they have 2 children, attorney Ian Spence Winder and Asha Marie Winder. Ladies and gentlemen, I don't know about you, but I'm excited to hear our speaker's thoughts on status, rights, and obligations, legal issues in citizenship, immigration, and asylum laws in the Commonwealth of the Bahamas. Without further ado, please welcome Sir Ian Winder, Chief Justice of this great Commonwealth.
Is that okay?
No, okay. Please be seated. I wish to thank the principal for setting the protocol, which I gratefully adopt. Thank you, Margaret Ellis, for that very warm introduction. Right. So let me begin by expressing my gratitude to the Eugene Dupuch Law School for the invitation to deliver this year's Eugene Dupuch Distinguished Lecture. Having attended many of these distinguished lectures delivered by eminent speakers, I'm humbled to have been given the opportunity, the high honor of addressing this forum. I will issue the usual disclaimer that nothing I say in this presentation binds any future decision in the event any case may subsequently be brought before me. As some of you know, I have a household of lawyers and a law aspirant. So when Principal Bastian Galanis asked me to deliver this address, I decided to ask them what would be a good topical issue which I could speak on. I expected, as I saw myself as somewhat of a commercial judge, I would have to choose some nice commercial topics. To my surprise, and I confess disappointment, they each said that I should speak on issues of immigration and citizenship. I have to accept, and I do, that this is the current issue which the media, civil society, the executive arm of government, and the legal system grapples with. Every newspaper this week carried multiple stories on immigration and citizenship. The ongoing turmoil in Haiti keeps these issues in the forefront of our minds. The title of the presentation, I think, speaks for itself. Citizenship, immigration, and asylum issues are interrelated. It is hoped that in the discussion, I will simply trace and consider the legal issues which the courts of the Bahamas have had to deal with arising from citizenship, immigration, and asylum in our 50 years of existence as a nation. Civilization in these islands throughout their known history, have been plagued by immigration issues. The Arawak civilization was extinguished as a result of European migration. Early English settlement began as a result of exiled Puritans landing on Eleuthera from Bermuda in search of religious freedom. In the next phase of the development of these islands, African slaves, whose descendants now make up 85% of the population, were migrated here by force. Later, the fallout from the American War of Independence saw large numbers of Americans loyal to the British Crown migrate to the Bahamas. They settled in the Abacos, Eleuthera, Long Island, and Great Exuma, along with their slaves in considerable numbers, having been gifted large parcels of land to compensate for the plantations lost during the American War of Independence. In his book, The African Diaspora in the Bahamas, Professor Keith Tinker includes a chapter which he titles Caribbean Migration and the Making of the Modern Bahamas. He writes, in the late 1970s and early 1980s, thousands of Bahamian children were taught primarily by Jamaican teachers in the public school system. Then, many of the local prison officers were Trinidadian. A significant amount of police officers were Barbadian. Haitians were the most popular tailors, and Guyanese dominated the land surveying sector. The migration began as a steady stream in the 1920s. Caribbean immigrants, mostly of African descent, effectively impacted all spheres of life in the Bahamas, almost as dramatically as did the migration of the Loyalists from the United States in the late 1700s. In consequence, thousands of new black immigrants swelled the populations of the islands and impacted every sector of life. This wave of immigration, in many ways, helped to shape the modern Bahamas. Whilst within the region, a fair amount of Cubans and Jamaicans have reached our shores, undoubtedly the single largest population of migrants, legal and illegal, have come from our southern neighbors, the Republic of Haiti. As far back as 1980, in a case called Jean and Others against the Minister of Labor and Home Affairs, Chief Justice Vivian Blake highlighted the then burgeoning challenge of Haitian migration. He recorded in the evidence that the Consul General for the Republic of Haiti estimated the number of illegal immigrants in the Bahamas at between 7,000 and 10,000, with the government estimates at over 20,000. The 2010 census, some 30 years after Jean, estimated that there were nearly 40,000 Haitians living in the Bahamas. This was more than 60% of the total number of foreigners in the country. The recently released 2022 U.S. State Department Human Rights Report on the Bahamas cites unofficial estimates at between 30,000 and 60,000 residents of the Bahamas were Haitian or persons of Haitian descent, making them the largest ethnic minority. The results of the COVID-delayed 2020 census are not yet available. The expectation certainly is that the numbers would have increased. According to the statistics provided by the Ministry of Labor and Immigration, 4,748 persons were repatriated in 2022. 71%, or 3,349 of these repatriated, were Haitian nationals. Citizenship and the right to it is impacted by migration, be it Bahamians moving out of the Bahamas abroad or immigrants moving into the Bahamas. Citizenship rights apply whether the persons involved were in the Bahamas illegally or not. The determination of who is or who is not a Bahamian citizen begins with a reference to Chapter 2 of the Constitution. The Constitution recognizes various routes to citizenship, depending on place of birth, the status of the mother and or father, in addition to marital status, marriage to a male citizen, or presence in the country before 10th July 1973. The Constitution expects Parliament to make laws for the attainment of the citizenship rights conferred in Chapter 2 of the Constitution. The Bahamas Nationality Act sought to fulfill this obligation. Early challenges to citizenship centered on the failure of the government to issue citizenship when persons felt otherwise entitled. In the case of Ryan and the Attorney General, the appellant, Thomas Darcy Ryan, a citizen of Canada by birth, claimed to have been ordinarily resident in the Bahamas since 1947, when he was then age 22. Ryan applied in June 1974 under Article 5(2) of the Constitution to be registered as a citizen of the Commonwealth of the Bahamas, having been ordinarily resident in the Bahamas for more than 3 decades, and having been issued a Belonga certificate pre-independence. The application was denied by the Minister of Immigration. Ryan challenged the decision up to the Privy Council. The board held that the Minister of Immigration had the sole jurisdiction, to the exclusion of all courts of law, to determine whether any facts existed to justify a refusal of the application. The board declared, however, that the decision to refuse Ryan's registration was null and void, and it struck down the proviso to Section 7 of the Bahamas Nationality Act. The board declared that Ryan was entitled to be reconsidered for his application for registration. Ryan was not registered as a citizen until 1993, some 13 years after the Privy Council ordered his application be reconsidered. Perhaps the most challenging immigration and citizenship issue is the case of a person affected by Article 7 of the Constitution. That article provides that a person born in the Bahamas after 9th July 1973, neither of whose parents is a citizen of the Commonwealth, shall be entitled, upon application, on attaining the age of 18 years or within 12 months thereafter, in such manner as may be prescribed, to be registered as a citizen of the Bahamas. It is clear that the Constitution offers, in the case of persons born in the Bahamas to non-Bahamian parents, a deferred right to citizenship, a right deferred to the 18th birthday. Some may also say that it is a deferred conditional right, as it seems that the application must be made within a window of 12 months. I've often heard the right diminished as simply a right to apply. It is certainly not a simple right to apply. Everyone and anyone has a right to apply. The right given to persons qualified under Article 7 is an entitlement to be registered upon application and subject only to national security and public policy considerations. The challenge for this class of persons is ascertaining their status in the period before age 18 and after age 19, in the event no citizenship has been applied for or granted. This was the issue raised in the case of Jane Roney Jane Charles against the Attorney General. The case involved a man of Haitian descent claiming to have been born in the Bahamas. He was arrested by immigration officers in September 2017 and detained at the Carmichael Road Detention Center. He was never charged with any offense under the Immigration Act or any criminal offense. Despite being detained, he was never served with a detention order or deportation order. He was deported to Haiti. In his absence from the country, a writ of habeas corpus was filed, which challenged the constitutionality of his detention and deportation. Mr. Justice Hilton, at first instance, ordered his return to the Bahamas. Upon his return, he was once again arrested and detained. The court then ordered his release from detention. On appeal, the Court of Appeal determined that there was procedural unfairness to the government in the conduct of the habeas corpus application, as the identity of the person detained, said to be John Charles, was never ascertained. This case was litigated up to the Privy Council, which, in a recent decision, held that there was procedural unfairness to the government. The Privy Council nonetheless held that it was permissible for John Charles to have sought constitutional relief in the context of the writ of habeas corpus application. There is some uncertainty in the law as it relates to this class of persons who, if not recognized by the Bahamas, often find themselves in certain circumstances, in certain limited circumstances, stateless. The situation is often compounded when they, by our application process, is forced to assume the nationality of their parents, if they can, in order to make the application for citizenship and access this deferred right. But what is their right to remain in the Bahamas? In relation to the immigration policy, as I understand it, persons in this class had long been recognized as having some right to remain in the Bahamas. By Section 30A of the Immigration Amendment Act 2015, the Director of Immigration is empowered to issue a resident belonger permit to persons impacted by Article 7. But what about the person who missed the window to apply established by Article 7? Jean Roney John Charles alleges that he was such a person, and on that basis challenged his detention and subsequent deportation from the Bahamas. There is an interesting statement at paragraph 36 of the recent Court of Appeal decision in Jean Roney's case. Paragraph 36 reads, "It appears to be common ground that the appellant did not apply for registration as a Bahamian citizen between his 18th and 19th birthday, as he may have been entitled to do so under Article 7 of the Constitution. It also does not appear to be contested that the appellant is entitled to permanent residence in the Bahamas." I'll repeat it. It also does not appear to be contested that the appellant is entitled to permanent residence in the Bahamas if it is established that he was born there and has resided there all of his life, or if he has traveled outside the Bahamas, he has done so and returned with the necessary travel authorizations. Now, since the Privy Council does not get it wrong, here is a clear statement as to what they understood the government accepted as the legal position. Where he did not apply for registration between his 18th and 19th birthday, he's entitled to permanent residence in the Bahamas if it is established that he was born in the Bahamas, he has resided there all of his life, or if he traveled outside the Bahamas, he has done so and returned with the necessary travel authorizations. Now, this statement in paragraph 36 is very likely to be argued as obiter dicta. But the statement as to the representation to the board seems clear. In any event, there is clearly a lacuna as to what is the status or right to a status for persons in this class who do not apply for citizenship in the window provided in the Constitution. In 2018, the Law Reform Commission had disseminated for public consultation an Immigration, Naturalization, and Asylum Bill. The intent of the bill was to repeal the Bahamas Nationality Act and the Immigration Act and establish an entirely new regime for the acquisition of citizenship and other status in the Bahamas, including as it relates to asylum. Under one draft of the bill, somewhat controversially, anyone born in the Bahamas after January 9, 1973 to non-Bahamian parents and who does not apply for citizenship before their 19th birthday would lose the right to apply for citizenship. Additionally, the bill would have given individuals who fall under that category 6 months after the law takes effect to apply for some form of status or risk being deported. It also established a right to abode in the Bahamas for anyone born in the country to foreign parents while they were a minor. The current administration has indicated, through the Attorney General, that it will introduce a new bill, although some of the concepts of the earlier Immigration, Naturalization, and Asylum Bill will be utilized. Attorney General Pinder is reported as saying that the better approach is to do an issue-by-issue approach rather than what would have been seen in the earlier bill. It is widely known that applicants often have to wait several years for the government to decide on their nationality applications, and in the interim do not have documentation to secure employment, housing, and public services. The lack of a passport also prohibits students from pursuing higher education outside the country. Until recently, these students would have had to pay the same rate, double the tuition, at the University of the Bahamas as would foreigners have had to. They continue to be denied the opportunity for government scholarships, notwithstanding their entitlement to be registered as a citizen, limited only by national security and public policy concerns. Respectfully, requiring people with these deferred rights, who are essentially Bahamians in waiting, to live on the outside of their own society is a recipe for social discontent, which we can hardly afford. There's absolutely no lawful justification why these applications ought to take years and in some cases decades to be processed. Such interactions leave a bitter taste and often hinder these Bahamians from fully embracing their Bahamian identity when their applications are eventually approved. Dr. Ian Strawn, I think, summed up the situation accurately when he stated, "Disenfranchising a person for 18 years or more while they await entry into the exclusive club of Bahamian citizenship creates frustration, shame, anger, alienation, and bitterness in the hearts of thousands of young people who know, have, and want no other home but this one. It is simply inhumane, short-sighted." Article 10 of the Constitution provides that any woman who, after 9th July 1973, marries a person who is or becomes a citizen of the Bahamas shall be entitled, provided she is still so married, upon making application in such manner as may be prescribed, and upon taking the oath of allegiance, or such declaration as may be prescribed, to be registered as a citizen of the Bahamas. There is a quiet, unspoken disdain by persons entitled to be registered as citizens under Article 10. This disdain is particularly acute among female lawyers who require citizenship in order to practice before the bar. The government has an interesting policy, reflected in several actual cases of which I am aware. After requiring the married woman to undergo a 5-year period of utilizing the spousal permit, they would offer them permanent residency, notwithstanding an application had been made for citizenship. As a practitioner, I had 2 colleagues who toyed with the idea of testing the policy, but ultimately the fear of jeopardizing their chances of ultimately gaining their citizenship caused them to get cold feet. Whilst no one has been courageous enough to challenge it, one has to ask, would interests of national security or acceptable public policy would warrant a grant of permanent residency to someone, but not citizenship, in circumstances where the Constitution confers an entitlement to be registered as a citizen? It is a fact that notwithstanding its expressions of fundamental rights and freedoms expressed in Chapter 3 of the Constitution, some provisions of the Constitution, in particular as it relates to Chapter 2, reflect differential treatment and certain classes of people, and it is particularly skewed against women. These anomalies are recorded by the report of the Constitutional Commission into a review of the Bahamas Constitution, dated July 2013, chaired by Mr. Sean McQueenie, King's Counsel. At paragraph 3.11 of the report, on this issue of citizenship, it stated, "This is, in many respects, the most singularly difficult subject the Constitution has had to consider. As might be expected, the Commission recommends that all of the provisions relating to the acquisition of citizenship and transmission to children or spouses be cast in gender-neutral language to provide for the equal attribution of the right of citizenship and to remove any discrimination against women in this and indeed every other regard." Further, at paragraph 14.26, the Commission went on to definitively conclude, "Many of the citizenship provisions outlined above describes a patrilineal and male-oriented constitution, one that relegates women to an inferior status in civil and social life because of gender. The Commission is unequivocal in its view that there ought to be no difference in the ability of Bahamian men and women to transfer their citizenship to their children and spouses. To provide for different treatment on the basis of gender is tantamount to saying there are classes of degrees of citizenship, and that the citizenship of a woman is somehow less than that of a man. Such thinking must be relegated to the annals of history. It can have no place in a modern Bahamas." Following the Commission's report, the government sought to address the anomalies by a referendum. The referendum failed to achieve the corrections of these anomalies. This was but a second occasion for which a government had attempted to bring gender parity. The government has indicated that it has drafted legislation to rebalance the gender anomalies. We await the release of the legislation for public consultation. There has been some commentary among some legal scholars expressing concern about the ability of Parliament to pass laws to confer citizenship outside of the Constitution in the wake of the defeated referendum some 6 years ago. It is my respectful view that this commentary is against the clear language of Article 13 of the Constitution. Article 13 provides that Parliament may make provision for the acquisition of citizenship of the Bahamas by persons who do not become citizens of the Bahamas by virtue of the provisions of this chapter. Parliament, having been elected by the people of the Bahamas and constitutionally mandated to ensure the peace, order, and good governance of the Bahamas, is empowered to enact legislation to balance any gender anomaly. Every citizen of this Commonwealth, regardless of gender, should enjoy the same rights. There is no reason why my mother, my aunt, my sister, or my daughter should not enjoy the same rights as I do to pass on my citizenship. Then there's the pending challenge to the interpretation of Article 6 of the Constitution. Article 6 provides that every person born in the Bahamas after 9th July 1973 shall become a citizen of the Bahamas at the date of his birth, if at that date either of his parents is a citizen of the Bahamas. The Constitutional Commission examined Article 6 of the Constitution and stated, the Commission is of the view that this provision is not discriminatory. It adopts a hybrid position between acquisition of citizenship based on birth, in territory, and descent, and the combination of each grants automatic entitlement at birth. However, it seems to have been susceptible to an interpretation that is discriminatory in its effects. This results from what the Commission considers, and with the greatest respect to the courts, to be the erroneous interpretation of the word parents in the provision to include an unmarried Bahamian mother, but not an unmarried Bahamian father. The courts have construed the reference to parents in Article 6 to be caught by the definition of father in Article 14, and therefore the potential benefit of this article to a child born out of wedlock in the Bahamas to a Bahamian male is removed. In the case of Roland, the Attorney General, the 5 applicants claim that they were born in the Bahamas and that their biological fathers are citizens of the Bahamas, but that their Jamaican and Haitian mothers are not. Their parents were not married at the dates of their births. They sought declarations from the Supreme Court that they are entitled to citizenship of the Bahamas pursuant to Article 6 of the Constitution. The Supreme Court held that a person born in the Bahamas is entitled to citizenship at birth pursuant to Article 6 of the Constitution if either of their biological parents hold citizenship irrespective of their parents' marital status. An enlarged 5-member panel of the Court of Appeal dismissed the Attorney General's appeal and upheld the Supreme Court's decision by a majority of 3-2. The Attorney General appealed to the Judicial Committee of the Privy Council. The matter was heard by the Privy Council on the 16th of January 2023, and the decision was reserved. Regardless of the outcome, the Board is expected to give guidance on the interpretation of citizenship provisions in constitutions and whether they fall to be considered on Minister of Home Affairs against Fisher principles. Citizenship rights are, of course, extremely important rights and the basis upon which certain other constitutional rights are derived. You would recall that Fisher principles call for the language of a constitution to be construed not in a narrow and legalistic way, but broadly and purposively, so as to give effect to its spirit, and this is particularly true with those provisions that are concerned with the protection of human rights. The flip side of the generous, broad, and purposive approach, as was advanced in Roe, is that derogations from rights must be construed narrowly in an effort to secure the most meaningful protection for the guaranteed rights. We await the decision of the Privy Council in this appeal. I now turn to consider legal issues relative to immigration in the Bahamas. In this discussion on immigration, we do not speak of those thousands of lawful immigrants who have helped to build and frame the modern Bahamas. The discussion is on illegal immigration. In framing the discussion and the challenge it posed to the Bahamas as a nation, I borrow another passage from the case of Jane and the discussion of Chief Justice Blake. He stated, "The applicants have fled their country for a better life in the Bahamas. The fact remains that they have no right to be here. They have come clandestinely to the shores and are part of the burgeoning population of illegal immigrants. They constitute a serious drain upon the limited resources of the Bahamas in many fields, particularly the social services, which are already stretched to the limit, to cater to the needs of citizens and permanent residents and those who are otherwise entitled to be here. So whilst illegal immigration is indeed a drain on our health, educational, national security, and social services budgets, we are a country where the rule of law and the Constitution prevails. Section 9 and 10 of the Immigration Act empowers immigration officers and police officers to arrest any person where there is reasonable cause to suspect the commission of an offense under the Act. Article 19(1)(g) of the Constitution provides that no person shall be deprived of his personal liberty save as may be authorized by law for the purpose of preventing the unlawful entry of that person into the Bahamas or for the purpose of effecting the expulsion, extradition, or lawful removal from the Bahamas of that person. Article 19(2) provides that any person who is arrested or detained shall be informed as soon as is reasonably practicable in a language that he understands of the reasons for his arrest or detention and shall be permitted at his own expense to retain and instruct without delay a legal representative of his own choice and to hold private communications with him. Much of the immigration challenges surround the proper treatment of persons who have been found in the Bahamas lawfully or where they are perceived to be in the Bahamas unlawfully. These issues include the proper process to be employed by the authorities upon arrest, and the extent of the right to detain illegal immigrants, and their treatment whilst detained. Applications to vindicate these issues are often pursued by a writ of habeas corpus application. In Aldenor against the Immigration Department and another, the applicant filed a habeas corpus application as she had been detained for 2 months by the enforcement unit at the Department of Immigration headquarters. It was believed that she had submitted a fraudulent application for citizenship and that she was illegally in the Bahamas. She had not been taken before a court to be processed. Supreme Court Justice John Isaacs, as he then was, found that Aldenor was being unlawfully detained, having been in custody for some 2 months on a suspicion of having committed an offense against the immigration laws and not taken before a court. In the case of Pierre Charles against the Director of Immigration, officers of the Immigration Department went to the home of James Charles on the 14th of March 2013 around 3 a.m. and arrested his wife, the applicant. Mr. Charles alleged that his wife was pregnant and naked at the time, and he had to beg that she be allowed to dress. The officers allowed her to get dressed. Mr. Charles said he explained to the officers that his wife had resided in the Bahamas for over a decade, having completed her formal education here. He told them that he and the applicant had recently married and that he had recently completed an application for a spousal residence permit and for her submission to the Immigration Department. He gave the documents to the officers. The applicant was arrested and taken into custody. Mr. Charles was told that once the marriage certificate was authenticated as genuine, the applicant would be released. He went to the Immigration Department the next day and said that he was informed that the certificate was fraudulent. Notwithstanding, he personally attended the Registrar General's Department and applied for and got a marriage license. 3 weeks after the applicant had been taken into custody, the application was made for habeas corpus relief and for bail. In granting habeas corpus relief, the court stated, Section 10 of the Immigration Act is a penal provision as it provides for penalties to be imposed for breaches of the immigration law. It cannot, of itself, be the basis for a person's detention unless he has been placed before a court, charged with an offense, and the court has issued a warrant of remand or warrant of committal for the person to be detained. It is an order of the courts or for deportation issued by the minister responsible for immigration, which provides the authority for the person's detention. No document purporting to authorize the applicant's detention had been produced to the court by the respondents. What these cases demonstrate is that detainees have the same rights to be protected against arbitrary arrest and detention as every other person who is alleged to have breached the law of the Bahamas. The unfortunate practice had been, notwithstanding these line of cases, to detain persons alleged to be in the country unlawfully for indefinite periods of time until they can be repatriated to their homeland. In recent times, certainly in the case of large illegal landings, persons are brought before the court. In some cases, because of the large numbers of persons involved, the magistrate often often have to travel throughout the islands of the Bahamas, most notably in Agua, to convene court to take pleas of illegal immigrants. The period of detention in Aldenor and Pierre Charles were 2 months and 3 weeks respectively. And whilst a day wrongfully detained is too long, it is with much regret that there has been many instances of much longer and more egregious periods of detention. Perhaps the most notable of these is the case of Attain Takitoda. Takitoda arrived in Nassau sometime on the 3rd of August 1992 from Osaka, Japan, having traveled through the United States. Upon arrival, he was given leave by the immigration officials to remain for 1 week as a visitor. Takitoda did not check into a hotel. Instead, he went straight to a casino to gamble. He alleges that whilst there, his luggage, which held his passport and other items, were stolen. That very night, police officers on Paradise Island picked him up on suspicion of breaking into a car and vagrancy. He was never charged with an offense. He was, however, reported to the Immigration Department. In August 1992, a deportation order for Takitoda was made by the Minister of Labor and Immigration. He was detained at Her Majesty's Prison, now the Bahamas Department of Correctional Services, as a result of the deportation order, on the ground that he was an undesirable and that his presence was not conducive to the public good. However, he was also never charged with illegal landing or any other offense that would have violated the Immigration Act. Ultimately, Takitoda was imprisoned for more than 6 years, initially at the maximum security unit and then minimum security. He was transferred to the Carmichael Road Detention Center, where he remained for an additional 2 years. Altogether, he was detained for a period of 8 years. In October 2000, Takitoda was released on bail after the hearing of his habeas corpus application. He sued for various breaches of his constitutional rights, general, aggravated, and exemplary damages arising from his detention. The Court of Appeal held that Takitoda was entitled to the protection of the law, regardless of the fact that he was not a citizen. The court stated that where an individual's liberty is restricted by the executive, the court should always regard with extreme jealousy any claim by the executive to imprison them without trial. The Court of Appeal considered that in the absence of a determination by the court that a person has breached the law, there was no basis for a deportation order. The entirety of Takitoda's incarceration was therefore unlawful. They agreed with the trial judge that Takitoda's constitutional rights under Article 17.1 and 19.1 had been infringed. He was awarded a total of $600,000 in damages, in addition to interest and costs. In the case of Ngumi and the Attorney General, Ngumi, a Kenyan citizen, was detained, arrested, and imprisoned from January 2011 for 6 years, 4 months, and 6 days. He was detained at his residence and taken to the Carmichael Road Detention Center. He was subsequently charged with overstaying and engaging in gainful occupation, contrary to the provisions of the Immigration Act, and brought before a magistrate. He pled guilty to overstaying and was acquitted of engaging in gainful occupation. The magistrate recommended deportation back to Kenya. In June 2013, Ngumi pled guilty to possession of dangerous drugs. Deportation was once again recommended. He was not deported, and in July 2017, a writ of habeas corpus was filed. In August 2017, prior to the hearing of the application, he was released from detention. At first instance, Justice Charles, as she then was, found that during his detention he suffered cruel and inhumane treatment, which included assault and battery. He was not charged with any offense under the Immigration Act. Justice Charles also found that his constitutional rights were breached. He was awarded a sum of $641,950, which included general and special damages. The judge held that Ngumi had been unlawfully detained, as after his arrest, he could only have been lawfully detained for 48 hours. Ngumi appealed to the Court of Appeal, seeking $11 million in damages. The Court of Appeal agreed with the learned judge's findings, but increased the damages award to $750,950. He has appealed to the Privy Council, and that appeal, which was heard recently on the 7th of February 2023, remains outstanding, having been reserved. Whilst these lapses by the immigration authorities have a tremendous impact on the detainees, they also have considerable impact on the country. As is evident, the financial costs of compensating these persons unlawfully detained amounts to many, many millions of taxpayers' dollars. Dollars which could otherwise have improved the delivery of education, health care, and social services. It would perhaps be unfair if I do not put forward one of the significant challenges experienced by immigration authorities in the case of some detainees. Immigration authorities often face repatriation delays where some countries do not readily embrace the return of their nationals. In Taki Toda, the Attorney General complained that they had nowhere to repatriate Taki Toda since Japan was unwilling to accept him. Also, in the case of Ramon Lop against the Attorney General complained that both the United States and Cuba, countries with which Lop had ties, refused to accept him. In those circumstances, what may have begun as a lawful and entirely proper detention with prolonged delays became unlawful. The law on this issue is fairly well settled, and the principles are rooted in a decision of Lord Justice Wolfe, as it then was in the case of R.V. Governor of Durham Prisons, ex parte Singh. A good distillation of these principles is to be found in the dicta of Lord Dyson in the English Court of Appeal case of R against Secretary of State for Home Department, ex parte I. He distilled the principles in 4 points. The authorities must intend to deport the person and can only use the power to detain for that purpose. The deportee may only be detained for a period that is reasonable in all the circumstances. If, before the expiry of the reasonable period, it becomes apparent that the authorities will not be able to effect deportation within the reasonable period, they should not seek to exercise their power of detention. The authorities should act with reasonable diligence and expedition to effect removal. According to Lord Justice Dyson, it is not possible or desirable to produce an exhaustive list of all the circumstances that are, or may be, relevant to the question of how long is it reasonable to detain a person pending deportation pursuant to the provisions of the law. But they include, at least, the length of the period of detention, the nature of the obstacles which stand in the path of the authorities preventing a deportation, the diligence, speed, and effectiveness of the steps taken by the authorities to surmount such obstacles, the conditions in which the detained person is being kept, the effect of the detention on him and his family, the risk that if he is released from detention, he will abscond, and the danger that if released, he will commit criminal offenses. Ex parte Singh principles were followed in the case of Kajipan against Bean. This was a 2021 decision of the Court of Appeal of the Turks and Caicos Islands. The facts of Kajipan were that on the 10th of October 2019, the police intercepted a Haitian sloop in the territorial waters of the Turks and Caicos Islands. There were 154 passengers on board, including 1 Indian and 24 Sri Lankans. Among the 24 Sri Lankan nationals were Kajipan and the 2 other applicants. Investigations were complicated by the language barrier, since the Sri Lankans spoke only Tamil, and comprehensive investigations were needed to take place to determine whether the detainees were victims of human trafficking. It was 2 months after the initial detention that interviews with the detainees commenced, following the arrival of UK-based investigators and interpreters. The investigations concluded that the detainees were victims of human trafficking, and the main suspect, a man called Chalea, was identified. 6 other detainees were identified as potential witnesses in the criminal proceedings. Chalea was ultimately extradited to Canada, where he was convicted of human trafficking. The remaining detainees, including the 3 applicants, were to be repatriated. The 3 applicants refused to sign voluntary departure forms, claiming that they did not wish to return to Sri Lanka for fear of what might happen to them upon their return. A notice of intention to make a deportation order had been given, but the order was made without any interview by an official with knowledge of and experience of asylum applications in accordance with TCI law. The COVID-19 pandemic and the subsequent closure of borders delayed the proposed repatriation of detainees. A writ of habeas corpus was issued on the 20th of April 2020, bringing the detainees before the court. At the conclusion of the hearing before the Chief Justice, she held dismissing the application that the delay in effecting the repatriation was not unreasonable in the particular circumstances of the case. However, following the Chief Justice's decision, the United Nations Human Rights Commissioner for Refugees subsequently interviewed and assessed the applicants and found them to be genuine refugees entitled to proper humanitarian care, and they were registered as such. The UNHCR requested their release. All of the detainees were conditionally released on the 24th of August 2020 after 320 days in detention. The detainees appealed the decision to the Chief Justice as to the lawfulness of their detention. The Court of Appeal, by majority, allowed the appeal. In a decision which I authored, we applied ex parte Singh principles. It was held that the legal principles relative to the power to detain had been breached by the respondents, in that the power to detain was not used for immigration-related examinations for which they were designed, but were actually used to investigate the human trafficking criminal offenses. That the period of time which the appellants were detained were not reasonable in the circumstances, as they were not criminals, but vulnerable adults seeking refuge. There were indeed barriers to any removal of the applicants, and therefore no purpose in properly detaining them while those barriers existed, and no prospect of immediate removal. And no due diligence or expedition was demonstrated by the immigration authorities in discharging their responsibilities under the immigration ordinance. The takeaway for immigration authorities is that whilst they have a deportation order for an illegal immigrant, they need to take immediate and appropriate steps to secure their deportation. Where barriers are encountered and it becomes apparent that those barriers may not be surmounted, the continued detention of the immigrant, although initially lawful, becomes unlawful. In the case of Usman Bojang and the Attorney General, the plaintiff was a national of the Republic of the Gambia. He sought political asylum in the Bahamas. He was arrested when he visited the Department of Immigration to seek an extension of his visitor's visa after he had overstayed. He was detained at the Kamaikoro Detention Center. The defendants attempted to repatriate Bojang to the Gambia on a flight via Cuba, but the attempt was unsuccessful because the Cuban authorities refused to allow Bojang entry for passage to the Gambia. He was ultimately detained for 18 months. Justice Charles held that Bojang was unlawfully imprisoned, as he was never taken before the court or charged with an offense, and was not the subject of any deportation order. As such, his constitutional rights under Articles 17(1) and 19 had been breached. In the circumstances, he was awarded compensatory damages in the amount of $161,000. Bojang's case demonstrates one of the barriers which countries like the Bahamas encounters in circumstances when application for asylum is refused. We do not have direct flights for many countries, and repatriation often requires passage through third countries. The third countries often refuse passage of the detainees for fear that they will seek to claim asylum whilst they are in transit and rely on the asylum laws there. Cuba refused Bojang's entry into their country in transit to the Gambia. The immigration authorities in the Turks and Caicos case of Kajipan saw similar challenges in their efforts to repatriate Sri Lankans. They had considerable difficulties in finding third countries through which to repatriate them. Canada in particular specifically refused to allow them to come through for the very same reason. Complaints have been levied at the state of affairs at the Kamaikoro Detention Center, where migrants are ordinarily held. The site was converted into a detention center in the mid-1990s to accommodate the increasing number of migrants. Those conditions have been described as consistently overcrowded with inadequate sanitation and medical care. International reports often cite widespread credible reports that immigration officials solicit bribes to facilitate better treatment. You would recall the fire back in 2004, started by detainees, destroying 2 of the 4 dormitories. You'd also recall back in 2013 the very public demonstrations in South Florida by activists alleging that Cuban detainees had been beaten by guards, denied access to adequate food, water, and medical care, and deprived of the ability to file asylum claims while they were at the detention center. There was also hunger strikes by some detainees protesting the conditions, including 6 Cubans sewing their mouths shut in protest of the conditions. The state of the detention center was considered in the case of Ngumi. Justice Charles found on the evidence that he was kept in deplorable, inhumane, and degrading conditions whilst being housed at the detention center. In so finding, Justice Charles found that Ngumi's constitutional rights against cruel and inhumane treatment had been violated and sought to factor this into the calculation of the award that he was entitled to. One of the more topical issues or headline-catching immigration-related issues today centers around the issue of irregular or informal communities, otherwise colloquially referred to as shantytowns. According to the report of the Department of Environmental Health called the Shantytown Report back in 2013, a shantytown is defined as a cluster of dwellings which do not meet minimum environmental or regulatory standards with respect to water supply, solid waste management, sewage disposal, general aesthetics, and structure. The report also states that many of the long-term residents of these shantytowns have assimilated and are recognized as productive, law-abiding citizens who contribute to the growth and development of the country. According to the report, many of the older occupants in these areas were farm laborers who were hired by diverse persons from throughout our society. According to a more recent U.S. State Department Country Report 2022, speaking to the shantytowns, they stated that informal communities house thousands of predominantly Haitian migrants, internally displaced citizens of Haitian descent, and stateless persons whom the government accused of constructing structures that failed to meet the housing code. In October 2022, on Abaco, immigration officers conducted multiple operations in one community which grew from 50 to 200 acres between 2019 and 2022, 4 times its size in just 2 years. Strictly speaking, the issue of the shantytown is not purely an immigration issue, but for the belief that the majority of the residents in these communities are migrants, both legal and illegal. The real issue is that they are unregulated, representing cities within the city. And being unregulated, the housing is more acceptable to those migrants who wish to live on the fringes of communities or who can only afford substandard housing conditions. Successive administrations have pledged to deal with these irregular communities, which pose health and security concerns for neighboring residents and the wider community. There's also a widespread belief that the majority of these communities are located on Crown-owned lands. In the case of R.V. Minnis, ex-parte Respect Our Homes, and others, 177 applicants claiming to be residents of shantytowns in New Providence and Abaco, along with a nonprofit company, brought judicial review proceedings in 2018 against the government, challenging a policy that they say was designed to eradicate shantytowns. The government had established a shantytown task force, which the applicants argued, based on the utterance of the then Minister of Public Works, was to eliminate shantytowns in the Bahamas and ensure that all residents of the Bahamas occupy housing in approved subdivisions by approved construction as per the terms governed by the regulatory agencies. In the action, the applicants sought declaratory relief as to the lawfulness of the government's actions and injunctive relief. An interim injunction was granted in 2018. In a recent February 2023 decision, the judicial review applications were all dismissed by Justice Grant Thompson and the injunction discharged. The matter is now the subject of an appeal and makes its way to the Court of Appeal. Article 1A2 of the 1951 Convention on the Status of Refugees and Stateless Persons defines a refugee as a person who is outside his or her country of nationality or habitual residence, has a well-founded fear of being persecuted because of his or her race, religion, nationality, membership of a particular social group or political opinion, and is unable or unwilling to avail him or herself of the protection of that country or to return there for fear of persecution. The Bahamas became a state party to the 1951 Convention and the 1967 Protocol relating to the status of refugees and stateless persons on the 15th of September 1993. Notwithstanding being a state party, the Bahamas has not passed legislation to give effect to its international obligations. Notwithstanding this failure to enact legislation to permit asylum seekers to obtain a determination as to their refugee status in the Bahamas. There is an informal process which permits the attainment of refugee status. Helpfully, the website of the Immigration Department directs asylum seekers to that process for applying for determination as to their refugee status. The asylum seekers would complete the necessary forms and undergo an interview. Assistance from the United Nations Commissioner on United Nations High Commissioner for Refugees and the IOM, the International Organization for Migration, is had to conduct the necessary research on the individual's country of origin and an investigation of the migrant, him or herself. At the completion of the refugee status determination, an assessment of the case is decided. The UNHCR has lamented that the lack of refugee legislation, policies, and contacts in the government complicated its work to assist asylum seekers and refugees in the Bahamas. The 2020 U.S. State Department Human Rights Report noted that the Bahamas did not issue any special refugee cards in 2020 to the approximately 30 asylum seekers during that year. These cards would have allowed refugees to work in the country. As a country, we became a state party to the convention and the protocol since 1993. Some 30 years later, whilst we have put in place the ad hoc mechanism to accept some asylum seekers to access asylum in the Bahamas, we have not honored our international obligations to enact legislation to formally provide for this to occur. The government has shared proposed legislation which seeks to cure this deficit, but no legislation has been tabled or further advanced. We all look forward to the completion of the process in satisfaction of our international obligations. In conclusion, we're going to get there. I'm reminded of the immigration quote that goes, "The venerated prophets, Abraham, Moses, Jesus, Muhammad, God's peace and blessing be upon them, were immigrants and refugees. Without their immigration, humanity would have lost the priceless good that they brought." We must bear in mind that immigration is not of itself a dirty word. Lawful immigration has always been encouraged in our country. I've already highlighted the contributions of so many groups of immigrants to our national fabric. Without immigration, many of our leaders and icons would not be here. Stephen Dillett, Mabel Walker, Celine Pinlin, Brent Simonet, Glennis Hannah Martin, 50% of the Golden Girls, Clay Thompson, Rick Fox, DeAndre Ayton. I could obviously go on for days. And depending on how far back I go, I could likely include everyone in this room. We fast-track permanent residency applications for high net worth individuals who buy second homes and engage in significant financial direct investments. We've also accelerated status applications for young athletes who have exceptional athletic talents and are needed to participate on national teams. I readily accept that for Bahamians, citizenship and immigration in particular are understandably emotive issues for us. I think everyone accepts that it is the specter of illegal immigration which draws the ire of most Bahamians. We are not alone in grappling with illegal immigration, which threaten the viability of many of our essential institutions. The Turks and Caicos Islands, our nearest neighbor, both in geography and culture, they have some of the very same, if not more dire challenges as we do, with human trafficking and illegal immigration, particularly as it relates to Haitian migration, being closer to Haiti than we are. Governor Dakin recently reported that last year, the Turks and Caicos Island Police intercepted some 3,000 migrants at sea, while the U.S. Coast Guard intercepted another 9,000 heading for their shores, and probably ours. Challenging legal issues relating to citizenship and immigration and asylum do exist in the Commonwealth of the Bahamas. As I've sought to demonstrate, many areas could benefit from appropriate legislative intervention, but many other areas, such as applications for status and prolonged detentions, simply require proper due diligence, timely interventions, and appropriate vigilance on the part of the immigration authorities. As to arrest and detention, authorities must recognize that while someone may have entered our country illegally and breach our immigration laws, it does not mean that they have surrendered all of their rights at the border. The power to arrest and detain exists, but the use of these powers, which affect the subject's liberty, must be exercised properly and within the legal and constitutional framework. Thank you. The principal beckoned that I would entertain questions. I know I've detained you long, but if there's a question I could take. Sorry.
I don't have a question, but I'd like to commend you for the thoroughness of your presentation and the work that you obviously put in. It is something that ought to have wider publication than the audience that you have there. I commend you for it.
Thank you.
Good evening, CJ. Just wanted to congratulate you on a wonderful presentation on what is the topic which needs some work. And I hope that what you've said here tonight will encourage the government to pass the nationality, immigration, and asylum bills, which have been gathering dust since 2018. Most of the issues which you spoke about tonight are covered in those bills. And so I certainly hope that the government will be encouraged to move forward with those bills. Thank you.
Chief Justice Weinberg, I just wanted to, first of all, congratulate you on your appointment and also to commend you for this beautiful issue of asylum and refugee law. Hits close to home. I'm very passionate about it. I represent the United Nations High Commission for Refugees here in the Bahamas, and I think this area or this topic with regards to refugee law is something that is very pivotal and critical. I'm hoping that with your passionate presentation and also with the former President of the Court of Appeal speaking today, that I hope that this resonates with individuals and that the political will to move forward with the legislation, that we have that encouragement to move forward. I've been in this capacity since 2020, and I can say that it's been very, very challenging, and it's been very murky with regards to whether or not we really want to move forward with this bill. As I listened to your presentation, the common thread throughout the entire presentation was that, especially within the legal community, we see a lot of habeas corpus applications being brought. And one of the things that really was brought home to me was that if the government of the Bahamas, and through strengthening legislation with regards to asylum, if this is strengthened, then we can save the country millions and millions of dollars in taxpayers' money with regards to damages, because you see where individuals like the government or can work closely hand in hand with UNHCR, especially when you're speaking about administrative detention, large amounts of damages are being given or being awarded to individuals. And I've been on both ends of the spectrum as an attorney and in this role, and I've seen the benefits of the government working closely hand in hand with UNHCR. And I see a clear gap, a clear absence of sort of UNHCR and sort of government collaboration. But the good news is, with forums like this, and I want to use this opportunity to not only introduce myself, identify myself, but also as a student, former student of Eugene Dupuch Law School, and student of yourself. I would like to use my relationship as being a Bahamian attorney to sort of foster that relationship, to see how we can organize more functions like this, also for the judiciary, because I think it's important that we have not only with the asylum process, we have an appellate process put in place as well too for asylum seekers, so we can sort of reduce the amount of cases in which attorneys bring habeas corpus applications and are successful in getting large amounts of damages. But I can speak on the topic for a long time. But I just wanted to and commend you for this beautiful presentation.
Thank you, Crispin. Crispin Hall.
Thank you. CJ, congratulations on a thought-provoking presentation. What I wanted to ask you, you talked about the better use that the damages monies could have been applied to had the government complied with their obligations. But what do you think about the role of damages in compelling administrations to do the right thing? It should never be, in my view, affordable to trample on people's rights. And I have a view about the conservatism of some of these awards. So, what do you think about the role of damages in inspiring the government to get a move on?
Strange enough, I was at a Caribbean Association and Judicial Officers Conference, and there was a presentation by Honorable Mayor Motley, who actually suggested that those damages awards should be capped, because it's not fair to states to have to pay for the acts of lone rangers, as it were. These officers who go off the path. But I guess they carry both. Yeah.
Not to be on the other side of Madam Motley.
That's it. Thank you. All right. Thank you.
Ms. Les?
Thank you, Justice. I apologize for making a return to the podium. As I am a student of Eugene Dupuch Law School, I asked for a 6-page memorandum, 1.5 space. I just have a quick question. You referred to Article 13 of the Constitution with regard to the government's intention to pass the nationality bill, which would seek to, what some have argued, to go around the Constitution's more draconian provisions with regard to Chapter 2. And I'm wondering, what is your opinion on the veracity
You could say they supplement the provisions.
Supplemental
not
provisions.
Go around.
Yes, Your Lordship. Well, and I apologize if this may compromise your ability to litigate the matter. But Article 2, could it not be argued that Article 2 limits Article 13 to such an extent that Parliament cannot step beyond what Chapter 2 has already espoused? So even though I think we all agree, and we would love the changes that you spoke so eloquently about and explained, but is it possible given the limiting nature of Article 2?
So what would Article 13 be for?
It's for, for Parliament to make rules and regulations within the parameters of Chapter 2. So it cannot go to the point where it is subverting the actual provisions of. I'm not saying that this is what I personally hope or agree with. I'm just saying that this is probably, how do we maneuver around that? Because, it is a serious impediment. In my opinion.
As you're about to leave Eugene Dupuch, you're year 1 or year 2?
Year 1.
Year 1, well, save your powder for get the right client, and you could bring this.
Thank you.
I know, right? Yeah. Oh, okay. I saw him on your one. Some of them. Super.
Protocol having been established, Chief Justice, the Honorable Sir Ian Winder, President of the Court of Appeal, Justices, retired justices, President of the Bahamas Bar Association, faculty, staff, and students of the Eugene Dupuch Law School, and all. A pleasant good evening. Chief Justice Sir Ian Winder, on behalf of our principal, Mrs. Bastian Galanes, faculty, staff, and students of the Eugene Dupuch Law School, we wish to thank you for taking the time out this evening to speak to us and afford us a wealth of knowledge with your captivating presentation on the pressing topic of status rights and obligations, legal issues in citizenship, immigration, and asylum laws in the Bahamas. I am confident that the information shared with us this evening will not only guide us in our practice, but will spark conversations and more action to initiate change. Thank you.
Ladies and gentlemen, we will soon be done, but I'm sure you will recognize the talent that, oh, I'm overcome. In short, I'm overcome. Justice Ian Winder, Sir Ian, delivered such an address, and I'm just so proud to have witnessed it. I'm so proud that he accepted our invitation. I'm so proud that grateful that he is here with us in this capacity. And all of that was just to get you to say, let's give him another warm round of applause. In 2012, the law school instituted, on the occasion of the Council of Legal Education's 40th anniversary, the Smokey Joe Award. We thought it then fitting to establish some formal recognition of persons who gave outstanding service to the council and or to the Eugene Dupuch Law School. The name Smokey Joe is derived from a weekly political and social commentary, Smokey Joe Says, written by Eugene Dupuch, which was published on radio and in the newspaper. The award, which you will soon see, is designed by Bahamian fine artist Jessica Colbert, and it features one of the symbols on the council's crest. At the inaugural ceremony, the Smokey Joe Award was presented to Sir Orville Turnquist of Britton Hall, the late Honorable Mr. Justin Austin Davis, who was the first principal of the law school, the Honorable Madam Justice Rhonda Bain, who's here with us, Mrs. Thompson Ahi, and Mr. Justice John Isaac. Since then, we've presented it to 9 other distinguished individuals, one of whom is also with us this evening, Madam Justice Retired Bodavo, who's the 2022 recipient. Not all of the recipients have been attorneys. However, each has exemplified tenets of the mission of the Council of Legal Education, namely the pursuit of excellence, the maintenance of high ethical standards, the promotion of social justice, and the strengthening of the rule of law. Moreover, each has given distinguished service to the Council of Legal Education and particularly to the Eugene Dupuch Law School. This evening's awardee is Sir Ian Winder. Sir Ian unquestionably satisfies the criteria established by the Eugene Dupuch Law School. Mr. Ellis earlier shared some of Sir Ian's extensive bio, so I need not recount it. It is enough to know that his journey in the law has been remarkable. He's traversed the public, private, and private bars, and of course the judiciary. But it is his touchdown in academia that we particularly cherish. We were delighted when, in 2009, Sir Ian indicated his indication to join us on a full-time basis at the law school. For almost 6 years, he was with us. His energies were directed at teaching and coaching and generally mentoring budding attorneys. He served on several committees of the Council of Legal Education. Even when called away by Sir Michael, who was then Chief Justice, to accept an acting judicial appointment on the Supreme Court, and then a full-time one. So Ian continued a full-time load at the law school whilst he was an acting judge. That, I dare say, is an indication of his passion, drive, and determination, and dedication. The scales shifted, literally, in 2014 when Sir Ian occupied the substantive post on the bench, and he became then an associate tutor at EDLS until 2022. In fact, even after his appointment as Chief Justice, Sir Ian was marking examination scripts. Thank you, sir. His commitment to legal education is evident, and his service to the Council of Legal Education and to the law school was exemplary. We are honored that he has agreed to accept the 2023 Smokey Joe Award. Sir Ian, on behalf of the Council of Legal Education, faculty, staff, students of the Eugene Dupuch Law School, it is my privilege to present you with this Smokey Joe Award 2023. I think he's talked out.
I'll just briefly say thank you. I've been to law school so long, I've admired it so long. I saw Ruth got hers last year. They said I was still on faculty, so thank you very much.
Ladies and gentlemen, thank you all for attending. Thank you for your attention. We look forward to welcoming you next year. And please join us now for a small reception. Thank you so much.